Roman 1 and 2. And we do indeed submit that there are compelling reasons why an appeal should be heard. Before we even get to and independently of the fact that in our submission with respect, there's a reasonable prospect that an appeal court would arrive at a different conclusion. So to start with the issue of the compelling reason for the purposes of 17(1)(a)(2), Roman 2, as the court is aware, there have been certain challenges of late in various courts to regulations and executive action under the Act. When I refer to the Act, I'm talking about the DMA. There have been certain decisions that have been, now leave to appeal has been granted, and whether it goes to the SCA or the Constitutional Court is another issue and remains to be seen. But there are, with respect, a number of reasons why we submit that there's a compelling reason for this appeal to be heard. This is the first and the only matter where a decision has yet been made in relation to tobacco products and cigarettes. We are aware that there is a pending application in regard to the same products that is currently pending before the Western Cape Court, High Court. That we understand is still to be heard, but it's quite clear from these decisions, well, these matters, the huge public interest that we submit a need for an appeal court to finally determine this issue. So we submit that it cannot be disputed that what is raised in this application is a matter of significant public interest. It is of national importance, and we submit that that in itself is a ground under Section 17 to grant leave to appeal. And as the court is aware, we seek leave to appeal to the Supreme Court of Appeal. We've quoted in paragraph 8 of our heads a decision of the SCA in BDK. Now that's an a fortiori case because there, in fact, the court was concerned with special leave to appeal. We concerned with respect with leave to appeal without having to show special circumstances, but we submit if special circumstances are indeed required, they certainly arise here. And we submit what this appeal does is it raises substantial points of law, which I will be addressing. It's a matter of great importance to the parties, and indeed a matter of great public importance. And we submit with respect to refuse leave to appeal, it would result in a manifest denial of justice in this case in regard to what is at stake. So we submit...
Mr. Subel, sorry to disturb you. I think you've said a mouthful. Just for our own following of your submissions, you're relying on both legs of Section 17(1), or of 17, that is 1A and 2, right? Am I correct? So are you going to be making your submissions in that line without telling us that you are now in 17(2 or you're still in 17(1? Or I just need to get that guidance from you.
No, of course. So yes, what I'd indicated was I was starting with 17(1)(a)(2),
right,
which is the subsection which refers to other compelling reasons why the appeal should be heard. And the compelling reasons, as we've submitted, are the matters that I've just indicated, the significant public interest, national importance, and the factors that were identified, as I indicated in paragraph 8 of our heads, in the BDK and sales high CC matter. And your lordship and ladyships will see in paragraph 29 of that judgment, there's a reference there to a number of criteria that would be relevant in assessing there in the context of special leave. We're not even dealing with special leave, but we submit those criteria are equally applicable here. And what I was indicating, my lord, is if you would have regard to paragraph 29 in the BDK judgment, you will see It's about 10 lines or so into that paragraph 29 of the judgment, is a reference to what would constitute special circumstances in the context of special leave to appeal. And there, as is set out, it raises substantial point of law. It's a matter of great importance to the parties or of great public importance, where the refusal of leave to appeal would probably result in manifest denial of justice. And as the court there stressed, that is not an exhaustive list, and that there may be other circumstances which also justified. But even those factors that are listed there, we submit that the application in this instance ticks each one of those boxes and would justify, certainly, without even getting into the merits, under 171A1, we submit that this qualifies as a matter which cries out for an appeal court and for determination. And I will address you in a moment on what these special points of law are, what is novel, we're in uncharted territory here, and also factually, why we submit with respect that these are matters that require an attention of appeal court, and indeed we submit with respect urgently. So when it gets to the category dealing with special circumstances and dealing with the concept of a substantial point of law, as the authorities have indicated, we've referred to the body corporate decision in case lines 024-4, it's about the third way down. We've referred there to the principle that dealing with what is a question of law of importance, it's not, you don't test it with reference to difficulty or complexity of the question. In this instance, we submit in any event, what we're dealing with does qualify as a difficult or complex question of law. It's a question of what the threshold is under Section 21 for the purposes of the regulations. And we submit with respect, in any event, one doesn't need to demonstrate that it's a difficult or complex question, but rather, as was set out by the SCA in that decision, whether the law is raised over or involves a matter of principle, rendering it important. And we submit it's difficult to imagine a case which calls out more clearly for a res nova or a matter of principle rendering it importance to be determined than a matter of this nature. And we've also pointed out we're not only restricted in that decision and what we submit should be decided by an appeal court, we're not restricted even to this case, because there are many decisions, no doubt, that would be influenced and many aspects of executive conduct that would be influenced by decision as to what is or what is not permissible. And we submit with respect, one requires guidance, and the minister requires guidance from the highest court as to precisely what is the approach to be taken in making regulations. Is it a PECO decision type principle, which I will address independently, or is it something less that this court has found? And we submit with respect that principle is of enormous importance and does require, particularly in the trying times that we're living in, requires urgent determination and a definitive determination with respect from an appeal court as to what the approach is. So the principle that is at play here, in other words, what is the approach to a regulation promulgated under Section 27, is res nova. It is certainly a complex issue, but in any event, it's a matter of principle that does require a determination by an appeal court here. So I've been addressing the court on 17182 to indicate why, with respect, we submit that ground in itself justifies an appeal court hearing, and which should be determined. And when I get to the grounds under 171A1, in other words, the question of the reasonable prospect, and we submit even there, we will deal with the question of what the legal issues are and why it is novel, why it is a matter of principle that requires an appeal court to make a decision. So if I can then turn to the section 17(1)(a)(1). And as the court is well aware, the question is whether there's a reasonable prospect of success for the purposes of 1A, and that's whether or not there's a reasonable prospect that an appeal court would come to a different conclusion. So we are certainly alive to what the threshold is, and it's whether another court would, but ultimately it's a question of a reasonable prospect. We don't have to persuade this court that this court is necessarily wrong, or that there's a clear prospect of success. We need to demonstrate with respect reasonable prospect of success, to use the wording of section 17(1)(a)(1). And with respect, it's on that basis that we've then set out broadly 10 grounds in support. Now, the respondent categorizes our approach as nitpicking. It's not nitpicking with respect, because we submit these are findings that lie at the essence of the matter. Before I get into each of them, if I can perhaps just also at a preliminary level indicate what we submit is the fundamental issue that requires a determination and reconsideration by an appeal court. And firstly, there's a legal one, and that is what the threshold test is under section 27. The court will recall that we addressed the court on the previous occasion as to the context of 27, which should be read with section 26. And we submit with respect, being a sui generis situation, being a national disaster, one needs to read this as requiring and justifying executive action where there is a national disaster and for which a particular measure is necessary. And we've addressed the court, I don't want to repeat the argument, but the question is, for the purposes of subsection 27(3), where the court is aware, it reads, the powers referred to in subsection 2 may be exercised only to the extent that this is necessary for the purpose of. And the first we submit with respect, fundamental inquiry here is what is meant by that. Is it the lower threshold that with respect this court found, whether or not it's reasonably necessary? If the minister concerned considers for a rational reason that it's reasonably necessary, is that sufficient? And we submit with respect not. And that's the first point of divergence we have with the respondent's approach and with the approach that this court took in the judgment. So we submit with respect that section 27(3) requires a definitive determination by an appeal court to give direction as to what is meant by the words only to the extent. And the words only, the word only is important because it's contemplating that it's a very limited power. It's there for crisis management. It's there for the purpose of achieving what is necessary. And the question is, what is necessary? If it's with respect, and then it's going to be an objective inquiry, which I'll address separately, but at legal principle level, we submit the appeal court should determine what is the level of the threshold for executive action here. And this court distinguished Pecco's case, the Constitutional Court decision, on the grounds that we submit with respect don't justify a distinction. Then the principle is indistinguishable. This court found that it's distinguishable because there we're dealing with evictions, and in particular factual circumstances. We submit with respect the principle that was set out by the court there is indistinguishable. And what the court there, the Constitutional Court, said was that it's got to be absolutely necessary because we're dealing here with disaster management and we're dealing with limited powers because this is not a power that's exercised by Parliament or where there's usual oversights on where we have the legislative process. This is where there's executive action by a particular minister, and these are, with respect, very serious circumstances, and there's got to be, with respect, a necessity for the exercise of that power. And the preamble to section 27(3) we submit makes it absolutely plain that the powers under sub 2 may only be exercised where it is absolutely necessary to do so. And we submit if the approach that was adopted in PECO's decision is applied in our case, the inquiry would be very different, because then the test and the analysis of the evidence that the minister relied upon, we submit with respect, would be a very different one. So if there's a legal principle as a starting point, if there's a legal principle the court interpreted section 27 and particularly 27.2 and 3 as permitting the minister here to exercise the powers only to the extent that it's absolutely necessary to do so, as in PECO's case, for a particular purpose, to achieve this particular purpose, then we submit with respect that will influence the factual analysis and the inquiry and the approach. And if that's so with respect, that would mean both at a legal, conceptual, as well as a factual level, there's a reasonable prospect that another court may adopt a different approach and come to a different conclusion. So the interpretation, which we have addressed previously, is of fundamental importance here. And it does tick the boxes both under 17.1a, 1, Roman 1 and 2. And that is, with respect, in our submission, a particularly important starting point in this inquiry today. So the approach taken in the judgment of this court was that we had pitched the threshold too high. That may be right, may be wrong. That's a matter we submit with respect, deserves the attention of an appeal court to finally determine in the context of the regulations generally under section 27, what is the test? So we submit that the test that was adopted by this court is far too benevolent in favor of the regulation. And we submit with respect that that is a matter where there could be reasonable prospects that there would be a different approach to it. So that's the first, and we submit a very fundamental and important point of divergence. And allied to that is the second and equally important point, and that is the approach that the court took to the evidence that was relied upon by the minister. And again, without re-arguing the matter, we submit that, in summary, the following arises. The approach this court took was to find that it was sufficient if the minister considered, for a rational reason, that there was a sufficient link between the banning, the regulation banning the sales, and the object, which was to relieve the burden on the health services. And the court, and we support this, the court took the approach that you don't need to resolve the competing views of the different scientists and medical experts and the evidence that's put up both ways. But, my Lord, that's where we submit what we agree with ends, because what then happened was, on the basis of what was referred to, and we submit wholly inconclusive and unreliable, we submit that the court went too far in finding that it was adequate for the minister to rationally link the sale to the object that was sought to be achieved. And the approach taken by this court, we submit with respect, was far too benevolent, as I've indicated, to the minister in exercising a power that has to be very restrictively interpreted. It's a draconian power. It's a very far-reaching one. It's there for a very limited purpose, and no doubt for limited time as well. This matter is now dragging on indefinitely. It's 4 months down the line with no insight to the lifting of the ban. And with respect, it's a matter that is of enormous concern and growing increasingly concerning, that this ban is considered still to be rationally linked to the object. And with respect, there's been absolutely no evidence, not empirical or any other at any other level, of that link. So we do submit that when it comes to the analysis, and nobody disputes whether or not smoking or the use of tobacco products is hazardous to health, what we need to find is that there's a sufficiently rational link. We submit it's not sufficient. Sufficiently rational link on even what the minister relied upon between the banning of the sale of these products and the relieving of the burden on the health services. And what was set out, and the court will recall during the argument, we made reference in Dr. West's report, in case lines it's 007-271. And I don't refer to this in order to persuade the court of the correctness of a particular view, one way or the other. But what he says here, we submit is common cause. It's not with respect a controversy that needs to be resolved. And where he says in paragraph 9, in my opinion, regulation 27 is illogical and harmful. Now, we look at why he says this, and we submit what he says here, in this case, with respect, cannot be gainsaid. And again, I want to stress, we don't suggest that we need, and we certainly appreciate that we're not inquiring currently as to whether or not the court was wrong or right. The question is whether or not what he sets out here has a reasonable prospect of a different view on an appeal. And he says it's illogical and harmful in that regulation is based on low to very low quality evidence. Let me just pause there. We submit, when we look at the WHO and the HSRC data that was relied upon, and bear in mind it was also at a very early stage, but at best in its own terms, it was inconclusive. And when he says that the view has been based on low to very low quality evidence, we submit there's no argument to contradict that. On any approach, even the ministers, we submit that it's quite clearly low to very low quality evidence. In fact, we submit it's not evidence, as a court would recognize, for which the data is not wholly available. There's nothing in what he says there that is contradicted factually. Does not consider short-term harms associated with voluntary and involuntary smoking cessation. And there, with respect, he's absolutely correct as well. There's no evidence that there's a proper appreciation had for the short-term harms associated with the voluntary, involuntary smoking cessation. Does not consider WHO recommended best practices in supporting smoking cessation to improve successful quit attempts. Does not acknowledge the negative impact that Regulation 27 is likely to have on vulnerable South Africans, for example, homeless, unemployed, impoverished, mentally ill, and does not reference any of the more recent literature that makes reference to the complex relationship between COVID-19 and smoking. And we submit, critically important, is that even on the minister's own approach here, it's not been demonstrated that the regulation banning the sale of the product is likely to have any meaningful effect on either the prevalence of smoking or any of the health-related benefits or relief on the pressure on the healthcare system. So we submit, in order to overcome that, it would need to be demonstrated that that the long-term effect of smoking on smokers' health is going to be meaningfully reversed or alleviated, such as to prevent or to avoid them having to place an increased burden on the healthcare system. But with respect, there's absolutely nothing to indicate that anywhere, even on the minister's own version and the evidence. The highest it gets to is a very crude, with respect, statement that within a couple of days, weeks, there's an increase in oxygen supply, but that, with respect, doesn't get anywhere close to what we're dealing with here. So we submit, with respect, that when one looks at the evidence relied upon and bears in mind that this, on any basis, from a scientific basis and as far as the court of law is concerned, could be regarded as no higher than low to very low quality of evidence. And the question is whether that could ever suffice. And we submit, with respect, what was relied upon, in its own terms expressed, that it was inconclusive. The court will recall, particularly in my replying argument, I referred in detail to the literature that was relied upon. And we submit, with respect, that it could never be sufficient. But again, the question is there a reasonable prospect? Another court may take a different approach. We submit, with respect, clearly so. So when we deal with the rationality, we've highlighted in our heads the importance of the considerations. A, whether or not there's likely to be any significant or meaningful improvement in health by cessation of smoking. But then very importantly with respect is those who do smoke during this period and who don't have a history of smoking, again, one asks rationally, will that result in any increase in the burden to the health services? It doesn't appear that there's any rational basis for that either. Also, very importantly, and with respect, something that we submit that a different court may come to a different finding on is whether or not the illicit market has in fact blossomed, and whether or not at this point in time, we're not talking about the time when the original HSRC review was done, at a very early stage when smokers still had stocks of the product. We're talking about on an ongoing basis whether or not it could be realistically said at this stage, or when the promulgation of the regulations 2745, that in fact it was going to lead to a cessation of smoking. And the best that the minister could say was, from some very, very rudimentary survey at a very early stage, it appeared, and no higher than that, it appeared that certain people had stopped smoking. Well, as is pointed out by the experts, for how long? And the experience is that smokers who stop then start again. But these are all matters with respect that one would have expected a far more solid basis for demonstrating that there's a quitting of smoking, and then demonstrating the link between the quitting of smoking and the increase or the improvement in health, and therefore alleviating the burden on the health services than what we have here. So we submit again, and again, it's simply a question of, is there a reasonable prospect that a different court may differ on this? We submit certainly so. And we submit with respect that those are issues that certainly justify and require the attention of an appeal court. So we've set out then a number of, those are two fundamental pillars we submit for why we submit, if on either of those or both of those issues, an appeal court were to differ from the approach taken by this court, then with respect, there is more prospects of success. We have set out various grounds, and I'll deal with them briefly, mindful of the time constraints. But, for example, we raise a cost issue. Now, we don't raise cost issues, we've said in our heads, we don't raise that simply because we say the court was wrong in it. We're quite mindful of the approach generally to costs, and it's a discretionary matter. But why we've raised it is because we understood that in court, the Respondents' Council expressly stated that they were not seeking a cost order. And yet the court then, mero motu, made a cost order as was made. And again, in itself, it wouldn't be ordinarily a ground, but it's part and parcel with respect of a number of grounds which we rely upon. And we submit with respect it's an injustice in this type of case where we're dealing with an interpretive issue of public importance, that the order was made in the terms that they were. As far as the regulations 27 and 45 are concerned and the ultra-virus nature of it, that's where we argued and we persist in the submission that we need to determine what is meant by necessary. And if in fact the appeal court determines that necessary means, as in Pecco's case, it must be held to be necessary in the sense of absolutely necessary to avert or to address a particular disaster at the time, then with respect we submit that this regulation would be ultra vires because it would be exceeding the powers which have to be restricted to the situation where it's absolutely necessary. So we submit that the section, and can I take the court to page 24-8 of case lines, where we quote from Pecco, because with respect, these are this paragraphs 37 and 42 particularly, which we submit are particularly important for the purpose of the application today. And while we submit with respect, this court erred in distinguishing Pecco, because the principle that we see in paragraphs 37 and 42 with respect is of universal application and certainly applies in our case. So if I can pick up a paragraph 37 of the Pecco, the Constitutional Court judgment, where the court said this section, and its equivalent of the 27.3, must be interpreted narrowly If I can pause there, we submit this court approached the interpretation not narrowly, but rather broadly, on the basis that because we're facing a disaster and because of the particular circumstances, that we've got to give it a generous and broad interpretation. Now, we submit with respect that runs contrary to what the Constitutional Court said. The Constitutional Court, recognizing that this is a limited and it's to address a particular disaster, that the court deliberately said the section must be interpreted narrowly. A wide construction, said the court, may adversely affect rights in section 26. And the court will recall the address that we delivered in regard to section 26, because that's the backdrop to 27 and the context in which 27 must be interpreted. The language used in 55(2)(d) is critical, and as we've pointed out, it's the principle is what we rely on. The text must be interpreted in the context of the DMA as a whole, taking into consideration with its preamble and other relevant provisions support envisaged construction. The municipality's powers followed upon the declaration of a local state of disaster must be exercised only to the extent that it is strictly necessary for the purposes set out in 55(3). 55(3) is identical to our 27(3) for present purposes. So we submit that if the approach taken is, as the Constitutional Court said, it must be narrow and it must be, the powers may be exercised only to the extent that it is strictly necessary. Now that gives meaning, going back to section 27, as we're aware, 27(3) says, may be exercised only to the extent that this is necessary. This court has found that that means in context reasonably necessary. We submit with respect that runs contrary to the statement by the Constitutional Court that it must be strictly necessary. And that's why, with respect, I earlier addressed the court as the first point of departure, the threshold, the legal test, and we submit with respect, if the test is absolutely necessary, it will also influence the reasoning of this court, when this court found that you don't need to second guess whether the method is the best or most appropriate. Now, I'll address that in a moment, because we submit, perhaps our point is slightly different. We didn't suggest that the court should second guess the method or whether it's the best or appropriate. We're submitting that the question is the measure at all, in other words, the banning of the sale of the product, is it at all strictly necessary in order to achieve the purposes under the Act? And if you start off on strictly necessary, we submit the inquiry is a very different one. So we submit that insufficient weight was accorded in the current judgment to section 26. We submit that the powers under 27 are extraordinary, that on the approach of the Constitutional Court and in context, only where it's absolutely necessary must the ban be imposed. And we submit that the Act doesn't contemplate that there's a discretion unconstrained by objective rationality, or that's not supported by at least empirically based evidence, when you approach it on the grounds of, is this absolutely necessary? There must be an objective inquiry, and objectively the court should be satisfied that what has been imposed by way of this ban is absolutely necessary. So we submit with respect, and very importantly, we'd ask the court to have particular regard to paragraph 18 of our heads at case lines 24-9, because these are factors which we submit are not really controversial in this case. We submit with respect, when one looks at what we've tried to capture in summary in 18.1 to 18.5, we submit that there's certainly a reasonable prospect that the Supreme Court of Appeal would find that on the evidence, if you adopt the threshold of absolutely necessary, that the ban was not absolutely necessary. And let me just make it absolutely plain. We don't only rely on the threshold of absolutely necessary. We submit that even if a court were to find that reasonably necessary would suffice, which we submit is not the case, but even if we submit, even on that test, that these regulations don't pass or meet that threshold. So in brief, what we say about the the basis upon which the ban was imposed. Firstly, we submit that the literature, so-called scientific literature, because it's not scientific literature at all, it would be very strange indeed if one were to consider the literature that was put up by the second respondent, the HSLC and the WHO, as scientific in any way. It doesn't come close to what's scientific. But on the literature that was so-called relied upon, we submit with respect, in the absence of at least sufficient or credible evidence of a link between the sale of the product and the cessation of smoking, and in addition, you've got to bridge another gap here. You've got to link that. You've got to show that there's a reasonable likelihood of a significant cessation of smoking in sufficient numbers, and you've got to link that to a likely prospect of reducing the strain on the healthcare system. And we submit there's no evidence for that whatever. So one has to be careful, we submit with great respect, in not being unduly differential to the executive in this instance. And if I can just pause here, the court found in the judgment and made reference to authorities that recognize that courts should be differential to technical or expert bodies. We submit with respect that isn't the issue here, because the executive here is not the expert on those issues. We're not dealing here with being differential to experts. We're dealing here with somebody who relies upon what the most rudimentary, early, rough and ready survey that in its own terms expresses that the relevant tests haven't yet been done. So we're not talking about here, you have an expert or technical body that's set up and then makes decisions. With respect, what we do know is that the command council that was set up here, that does have the experts apparently on it, when the announcement was made by the president at the end of March, April rather, we know then that the decision had been taken, whether you want to call it as a preliminary or it was still open for debate, we can debate that endlessly. But quite clearly, from what was anticipated at that point, the council and the minister herself would have been satisfied that there's a basis to lift the ban. Now, what changed, and this changes in a very few days, was the fact that there was then public comment. And the public comment, then there was a number of so-called objections to the lifting of the ban. And the reason why we raised the ex post facto availability of this, for want of a better word, I'll call it literature, because it's hardly literature. What changed then was, at that point in time, when the decision was reversed and the announcement made at the end of April to impose the ban, the only thing that changed at that point from the minister's point of view, not as a technical expert, not as a medical or scientific basis, but that there had been some objections. And we showed the unreliability in that as well on our own version. So we submit with respect that it is a particularly low quality reason, one that could never justify rational imposition of the ban. And what came later even through the so-called literature hardly qualifies as literature. And we submit with respect, it is the most rudimentary, and as Dr. West points out, low, and with respect, we submit no quality literature. So we submit that firstly with the country.
The time now is 11 a.m. This is All Angles right here on ENCA. I'm Tumelo Mototwane.
Good morning. I'm Chula Sizwe Semelane. Thank you for joining us.
We are now being disturbed by the media.
A media briefing that's coming up at midday, roundabout midday.
Right.
Justice Crime Prevention cluster of government. They'll be talking about additional measures.
The media commute themselves
in enforcing the lockdown.
Well,
in terms of
these guys, they just button into our
But also we
hearing.
need to know what impact COVID-19 has had so far within the respective
Trying to
ministries.
unmute
We've been talking to, the correctional.
Right, we're going to come out of that process by the tobacco manufacturers who are currently making their legal case in court, trying to get cigarettes back on the shelves. We apologize for that broadcasting cross line there, but let's go on to other stories now. Right, we're going back to Pretoria now.
The prohibition And that's what's termed literature, and we submit literature as being unduly kind to what was relied upon. By no stretch we submit of any imagination can this be regarded as literature. And it's certainly not scientific by any means. The next issue is there's the link, and we submit with respect the premise that if a certain number of people, we don't know how many, what this number is, are prevented from gaining access to cigarettes and tobacco products for a limited period of time, that they will cease to be smokers. And realistically, we submit with respect that that's not the case, and it's not been demonstrated. Experience has always demonstrated, and this is not with respect factually controverted by the respondents in the papers. Experience has always demonstrated that ultimately the smokers and those who are addicted to the product will find it. They will source it in some way or another. So we submit with respect realistically, the sale of cigarettes and tobacco products cannot be prevented. And then, as I indicated earlier, there's also got to be demonstrated some prospect from on some empirical basis that any meaningful damage to a smoker's health would occur during the period of the temporary ban on sales, or that the health impairment that might have occurred prior to the ban will be improved and reversed. We submit absolutely nothing from any credible source to this effect. Very high level, superficial, and simply bald statements, and nothing more than that. And we submit with respect that as far as the court is concerned, if this were an ordinary civil trial where scientific evidence was required to prove even on the probabilities that these aspects would arise or would be met, we submit it would never satisfy any burden of proof. So we submit with respect that those are matters which there's a reasonable prospect of another court coming to a different conclusion. And we submit, therefore, that there's a reasonable prospect that the appeal court would find that the ban was not necessary, either absolutely, strictly necessary, or even reasonably necessary for the attainment of the objects of the Act. It must be the objects of the Act, ultimately, that is an issue. As far as the criminalizing conduct is concerned, again, there appears to be a misconstruction with respect as to about what we submitted. We were not attacking the provisions of the regulations that criminalize certain conduct or the Act. That wasn't our argument. Our argument was that when you make, as an executive action, when you make a decision to impose a particular ban, as we see here, or prohibition, and that's executive action we're concerned with, you've got to assess also in rationality what the effects are likely to be. And one of the factors we submit is the effect is that you're going to now render conduct that would otherwise be legal, because smoking and sales of tobacco and tobacco products in South Africa is legal. You're going to now, through this ban, render conduct that runs contrary to that criminal. And the point we're making is not that we are attacking the fact that you're criminalizing conduct. We're raising it in the context of the assessment of the rationality and indeed proportionality of what has been imposed. Is it proportional when you know that these are going to be the consequences where you're going to actually result, the prohibition is going to result in criminal conduct for what is otherwise not criminal. So we submit with respect there too, the emphasis we submit has been misplaced, and it really misconstrued what the basis was for our argument. The ex post facto justification, I don't need to re-argue. The point very simply is to demonstrate that when the first announcement was made by the president that the sale of the products was going to be permissible under the lockdown 4, and then the change in a couple of days, without that so-called evidence, and we submit it's really, to be kind to it, to call it evidence or scientific data or evidence, it was none. But we submit with respect that that change, based purely on what was submitted by members of the public who apparently had an objection to the lifting of the ban, we submit with respect, the ex post facto is relevant to whether or not there was indeed a rational basis and it was indeed shown to be absolutely necessary or even reasonably necessary at the time of imposing the ban. So we submit again that perhaps our argument, as we read the judgment, has been mischaracterized. We're not saying that you can't, in review position, ex post facto justify if there is one. We submit that what came later isn't a justification anyway. Our point was different. Our point was that the experts, the people who did consider the matter before, when the announcement was made by the president and before the ban was imposed a couple of days later, those people, with respect, did not have the justification in mind, nor did the minister, and with respect, for very good reason. So the question is, at the time that the ban was imposed then, at the end of April, what was the basis on which it was considered to be necessary? And we submit with respect, it's not a question of having an ex post facto, it's a question of, was there anything? And we submit, other than members of the public and perhaps certain people raising objections to the lifting of the ban, we submit with respect, there was absolutely nothing. So that's where, with respect, the issue of the ex post facto arises. And the argument that's been raised by the respondent and the way our argument is captured in the judgment we submit with respect misconstrues what our argument is. We also submit that when you assess the rationality and the proportionality, it is important that sufficient weight be given to all the other factors, the countervailing factors that were identified, the psychological, the physiological, the economic, the medical, the social, and the other harmful effects of the ban. And although the court did refer to it in the judgment, we submit there's a reasonable prospect of an appeal court attaching different weight or significance to those and coming to a different conclusion as to whether or not those factors should be sufficient to run counter to the reasons for the imposition of the ban. The illicit trade, the judgment deals again with that, and the judgment really approaches it, as we understand with respect, on the basis that it's a fact of life. You will not remove illicit trade, but even if there is some cessation in smoking, that would be sufficient. So even if certain people no longer have access to cigarettes and tobacco products, and therefore the sales are reduced, that is in itself sufficient. Now we submit with respect again, there's a reasonable prospect another court finds, A, that it is totally inconclusive over, we're not talking about the first 7 days after lockdown, over the period that these bans now endure, it's entirely inconclusive that there will indeed be a reduction in the sales of these products. Because we submit with respect, there's absolutely nothing to indicate that. On the contrary. And then we submit as well, there's a reasonable prospect of an appeal court finding that the people who, during the first couple of days or week at most of the lockdown did not purchase, will continue not to be able to purchase and will not access these products. And we submit it is so inconclusive with respect that we submit would never qualify sufficient evidence to make any rational decision, whatever the threshold is, whether it's absolutely necessary or reasonably. So we submit with respect that on the question of the illicit trade, it's a critical element here, because as long as you've got access to cigarettes and there is a blossoming illicit industry, we submit with respect that you're not going to achieve through the ban. And bans notoriously don't work when it comes to ending either alcohol-related activities or cigarettes. So we know what history has shown, and we submit with respect, it's a matter that also is deserving of the attention of an appeal court to find whether or not the approach taken by this court to a critical issue, being the illicit trade, is the correct one. Then on the ID Ultram, again, there seems to be, with respect to mischaracterization of what we were arguing. What we were saying, we're not talking about procedural rationality We were talking about the rationale by the minister to impose a ban at the end of April was based on representations that were made that supported a ban and were opposed to the lifting of the ban. We submit it's an unreliable basis. That's where our argument comes in. The reason it's unreliable is because after the announcement had been made by the president in the first instance, it is highly unlikely that many people who would otherwise have still petitioned for and supported the lifting of the ban would have considered it no longer necessary. And the fact that a day or two before the ban was imposed, there was a public announcement by the minister that it's now still open for discussion and consideration, we submit doesn't change that fact, because that's a very, very, very small window period, and in fact less than 2 days before the ban was actually imposed. So we submit the ad altrum argument that we addressed was not what is captured in the judgment, and as our learned friends have portrayed it. We are submitting, it goes to question not only of the applicant's ID, it goes to whether or not there was, if the approach was we're going to ban it on the basis of public representations, the question is, can this ever be a rational, reliable basis where you've led people to believe in the first instance that it's going to be lifted? So that's where it fits in. And again, another feature we submit in a number of features which bear upon the rationality of the process and of the decision. The other considerations, which is captured at page 24-16 onwards, which we submit with respect, should also weigh, and we submit there's a reasonable prospect that the SEA may take a different approach to this court. The economic impact, because ultimately it's a question of assessing the sufficiency of the so-called literature relied upon by the minister and weigh that up against what we submit is indisputable. The economic impact here, the shutting down of an entire industry, the vast number of people that are affected and prejudiced in their livelihoods in the industry, their only means to survive, the collapse of an industry and job losses. Ultimately, we submit there's a reasonable prospect that another court may say, taking a view here to balance it. On the one side of these scales, we'll put in the minister's justification that there's some benefit, some unarticulated, unquantified benefit, but there's some benefit. This court found that that was sufficient, but you've got to weigh that up against the countervailing factors. And the court, with respect, an appeal court, may reasonably find that weighing that up against what is indisputably the enormous prejudicial consequences of this ban, the court may find that it doesn't pass the test of rationality. So we submit again, those are factors which an appeal court may reasonably find differently in the assessment and weighing up the competing considerations as to the rationality. We've also dealt with the effects of the abrupt cessation, the absence of support, the rather glib, and we submit with respect, insensitive approach taken by the minister in relation to people can simply now substitute with nicotine substitutes over the counter, and they must really just get over it. And we submit it's a particularly callous approach that was taken to people who are addicted. And the approach taken by the minister, and the approach that was accepted by this court, is that it was sufficiently rational that the people who were required to abruptly cease smoking because they couldn't access products, that their interests were adequately safeguarded through alternatives. And we submit these are not alternatives. As the experts all recognize, and this isn't only the applicants' experts, there are programs that are directed at this. There's no support programs for people in this country who suffer the consequences of this. So certainly to a person who's addicted to these products, we submit with respect it's a particularly serious consequence, psychologically, physiologically, and with respect, it's been pointed out, Scott West, we submit with respect that there is an enormously prejudicial consequence, apart from economic, as a result of and that again must come into the mix and to the assessment of what is rational and what the test is. And again, this court may be absolutely persuaded about the correctness of its judgment. That's not the test. The test is whether there's a reasonable prospect on this matter that a different court would come to a different conclusion. So we submit with respect that there is. We then deal with the question of the essential goods. And here, with respect, we submit again that there's a reasonable prospect as to whether or not the court was correct in identifying, for the purposes of the original Lockdown 5 regulations, whether or not cigarettes, tobacco products qualified as basic goods. And this court adopted a justum generis approach to the interpretation. And we submit with respect to there's a reasonable prospect here again, where another court finds differently to that. We submitted that a justum generis cannot apply here. To put electricity and airtime into a particular genus, we submit with respect is clearly incorrect. So we submit with respect again, when it comes to what is a basic good. This court interpreted basic goods in the context of the preamble when it spoke about essential goods and services. But when we look at the list in the schedule, the annexure, we submit what the legislature had in mind there and what the original regulations had in mind was what's called basic goods. Now, the concept of basic goods and whether or not an addictive product, legal product such as tobacco and cigarettes, falls within basic goods, we submit there certainly is a reasonable prospect of a different finding on that. And the best indicator of this is that the minister herself considered it necessary to put it beyond doubt, because the original regulations didn't mention cigarettes and tobacco products. And because there was controversy, and the court will recall there was controversy in the different provinces as to whether or not those regulations did or did not prohibit cigarettes and the sale of cigarettes and tobacco products. And that's why, to put it beyond doubt, the first regulation 27 was then promulgated to make it expressly prohibited. Now that, with respect, we submit is a very strong indication that the initial regulations were open to the interpretation that the sale of these products was not prohibited. And we submit with respect, that's again another issue where there's a reasonable prospect of a different court finding differently as to whether or not, under those original regulations, there was a prohibition on the sale of these products. We've dealt in ground 10 with the rationale for the decision. I've already dealt with that largely, but I do want to just highlight the inadequacy of what is a very rudimentary, and I put it crude, survey that was conducted at it was between 14 and 21 days after the lockdown. That's the best it gets. But as we saw from the UCT survey, which started on the second last day of the level 5 and continued 11 days into level 4 lockdown, it showed a different result. And that study, the UCT study, showed that 90% of the smokers had stocked up on cigarettes before the start of the lockdown. And most had sufficient stock to last them throughout the period that the HSRC survey was conducted. Now, that's not a controversial matter. That just shows that there's absolutely no value in the HSRC survey. To base a prohibition of this nature on a survey conducted between 14 and 21 days after initial lockdown, with respect, is entirely inadequate. And we submit with respect, as was demonstrated by the UCT study, that for that period, 90% of the smokers had already had sufficient stocks. So we submit with respect, it's not a question of having to resolve competing versions and views. We submit with respect quite clearly, the HSRC survey is not one that can reliably be used to support and maintain the prohibition. And none of the surveys took into account relapse rates, and therefore the quit rates can't be drawn. There's no evidence at all about quit rates. So what are we left with ultimately? We're left with a totally irrelevant HSRC survey it doesn't demonstrate anything. We're left with the WHO, who themselves say we haven't done the analysis and we haven't done the tests that are required. And what we're left with is then some undefined, unquantified number of people who have objected to the lifting after the body that is supposed to consider these matters, the Command Council, were satisfied at the first instance that the ban was to be lifted under the lockdown 4. So we get back to the fundamental question again. Is there a reasonable prospect that an appeal court would find that applying the evidence that was before the minister, could that ever rationally justify this measure? And we submit there is a reasonable prospect that an appeal court finds differently to this court, and that finds that it is so unreliable that can't, on any basis, whether reasonable necessity or an absolute necessity, that it can't be sufficient to support the regulation. So we if you just bear with me one moment. So we submit with respect, if we look at the first leg, 17 going back there, 17182, which is the question of the circumstances, the national importance and so forth, we submit this is a matter that in itself justifies an appeal. And then factually we submit in any event, it satisfies the criteria of a reasonable prospect of another court coming at a different conclusion. So we would ask then that leave to appeal be granted, and we've asked that leave to appeal be granted to the Supreme Court of Appeal. We'd ask that the costs of this application be costs in the appeal, as the court pleases.
Thank you very much, Advocate Subel. We listened, and that's why we didn't disturb your argument. And we're now going to take a 10-minute break. And then when we come back, Advocate Moerane will take the floor. So the time is 11:23, so we'll come back 10 minutes thereafter.
Thank you.
Court adjourns then briefly.
Well, welcome back, and thank you so much for staying with us through that process. We'll continue to look at that the go back as soon as tobacco sales. Let's go there.
And it is our main submission that the rationality test is settled law and is correctly, with respect, formulated in the court's judgment. There's no prospect that an appeal court would hold otherwise, and we submit that leave to appeal on this ground must also be refused. Now, dealing with the rationale for the ban, we deal with this ground, and I'm not going to repeat this, at paragraphs 30 to 35 of our heads of argument. FITA again seeks to raise the same 3 points on which it relied in this court as a basis for irrationality, that the medical evidence is inconclusive, that people are still smoking, that short-term cessation has no benefit.
Yeah, that's it.
We submit that this court rightly dismissed these complaints and held that the decisions to promulgate regulations 27 and 45 were rational. We interrogated this at length in our main heads of argument and specifically rebutted each of the 3 points that FITA raised and now raises again. Though the applicant attempts to pick holes in the evidence that the minister put up, it has failed to show any reasonable prospect that an appeal court would come to a different conclusion. We submit that leave to appeal against the court's findings on rationality should therefore be refused. Now, dealing with the criminalizing conduct, we also deal with this ground of appeal at paragraphs 36 argument. The applicants argue that another court would have regard for the effects of criminalizing the sale of tobacco products and therefore find the prohibition to be disproportionate and irrational. However, the applicant continues to ignore the fact that it is not the impugned regulations that criminalize conduct. This is done by entirely different provisions, which the applicants have seen. We submit that this court was correct with respect to hold that a challenge to the legality of the offense creating regulations was not before it. And this is at paragraph 91 of the judgment. It remains unclear what impact the applicant thinks the offense creating regulations should have in this matter, or how it considers the existence of these regulations to be relevant to the rationality of the regulations it actually seeks to review. We submit that questions of proportionality have no place in a rationality review. In the circumstances, once again, the applicant has failed to make out a case that the offense creating regulations have any relevance at all. We submit that there's no reasonable prospect that the appeal court would alter the order made by this court and set aside regulations 27 and 45 on the basis that different regulations create criminal offenses. Dealing with the complaints relating to ex post facto justification, we deal with this issue at paragraphs 41 to 45 of our heads of argument. The applicant contends that this court ought to have had regard to the fact that some material on which the minister relied to justify regulation 27 was obtained after its promulgation. According to the applicant, this renders the process followed irrational. The applicant continues to gloss over the fact that it elected to review regulation 45 without affording the respondents an opportunity to file a record or reasons It was accordingly necessary, with reference to Regulation 45, to attach material to the answering affidavit that was considered after Regulation 27 had been promulgated. Regulation 27 had been promulgated. Regulation 27 had been promulgated. Regulation
Mr. Morane,